2 years ago, 2012, Dan Forrest was an endorsed candidate of conservatives for Guilford County. We were proud to get out and walk the grounds of Guilford County and help get this good man elected, and he's done a fabulous job for the citizens of North Carolina. I think we got him elected at least 4 times. He might have to correct me when he comes up here, but we had a primary, we had a runoff, we had a general election, and we had a recount. So I know of 4. And it was, we were very proud to be involved in that campaign, and we are very proud that Dan has come tonight to introduce the program first tonight, the Convention of States, and to come to our meeting. And I'd like to at this time welcome our Lieutenant Governor Dan Forrest.
It's an honor to be with you and back with so many friends, and we thank you for everything you do. This is the reason that we are here tonight to even talk about the Convention of the States is because we believe that our government should be of the people, by the people, and for the people. And the people should have a voice in their government. They should have a say. And increasingly in America, increasingly in North Carolina, increasingly out on the trails, I'm not meeting people. People will say, I don't believe my vote counts, and I don't believe my voice is being heard, and so I just don't participate. I don't really get involved in politics. I believe that's because through the years, the federal government has taken over such a large role of governance in America and has really pushed the states to the side. And our founding fathers believed really just the opposite. They believed that government should be operated at the closest proximity to the people, that the people's voices needed to be heard, and you do that by putting government as close to them as possible, not some faraway nebulous entity in Washington, D.C. that's trying to represent you. And so we're here today to talk about what was that process that our founding fathers believed in. What is the Constitution? What does the Constitution really say about the separation of powers in America? And we grow up going to school learning specifically about what I call this horizontal separation of powers that is between the legislature, the executive branch, and the judicial branches of government, and they're all supposed to balance one another out and hold one another accountable. We talk about that quite a bit, and even that's out of hand. But we oftentimes forget about the vertical separation of powers between the states and the federal government. And that's the one that really our founding fathers were most concerned about, because they knew full well that the national government would grow over time. It started right at the founding. It started growing right at the founding of our country. But they knew it would grow, and so they put protections in place so that our states would then still have a voice, that the people would still have a voice, that our states, our 50 states, could be 50 innovation laboratories in America. And you could go out across America and you could see things that are going well in one state, and another state could choose to adopt that. You could see things that aren't working, and the states could say, no, we don't want to do it that way, so we're not going to do it that way. And you don't always have to like what another state does. If you look at California now, and they're almost bankrupt, and you can look at them and say, well, if they're doing it the legal way, and they're going through their legislative process and creating laws the legal way, so you don't have to like them. They could be a socialist state if they want to, but you don't have to like them. You can move to another state, and the other states can do it differently. That's one of the great things about America is we have these 50 states. We all have opportunities to do things differently. But within that system, we're all supposed to have a voice. And so we're going to talk tonight about that. I'm going to introduce a couple of people here to talk about this process of the Convention of the States and why we think it's important right now in America and what we can do to get our voice back as Americans. It's what our founding fathers would have believed in. So we're going to talk a little bit about that. Before I introduce Dr. Michael Farris, I'd like to bring Bert Jones up. Bert, come on up. Bert is... from Rockingham County, and he is a delegate that went to Indianapolis this summer to talk about this process, the process that you'd actually go through for the Convention of the States, and it was, tell me the name of it again, the Legislative Assembly?
Assembly of State Legislators.
Assembly of State Legislators, and so he went to that. He's going to tell you a little bit about what happened in Indianapolis for a couple minutes, and then we'll get Dr. Farris up. So Bert, it's all yours.
Thank you, Governor Farris. I just want to take this opportunity publicly to thank our Lieutenant Governor for his leadership in the state on this issue and on many issues. It's certainly an honor for me to stand here shoulder to shoulder with him anytime, but to come and talk about this issue this evening that I think is extremely important. And if you haven't heard Michael Farris speak, you're in for a treat. I'm telling you, I've known this man for a long time. I've followed him in many aspects of his work, and to have him on the leadership stage nationally for the Convention of States is great. Let me just explain a little bit about the process. As a legislator, I really became involved with this starting about a year ago. There was an effort that sprung up among the states, a steering committee that got together that notified all 50 states and invited us to go to Mount Vernon, the home of George Washington, last December the 7th. And with just a few weeks' notice, we had about 100 legislators from 32 states all the way as far away as Alaska. They came to this meeting for the sole purpose of discussing a convention of the states, and that's where it was started as a legislative effort for us. Then we had, back in the summer, a meeting in Indianapolis, and Lieutenant Governor Farris sent myself and Representative Chris Millis. We were there to represent North Carolina at that meeting. And at that point, it became the Assembly of State Legislatures. We were no longer at Mount Vernon. But the purpose of that meeting was really to discuss a bit more in detail about the process. We didn't talk about particular amendments that would be offered at such a convention or anything like that, but the process. You know, the founders were very clear in leaving the process to the states. You know, people oftentimes forget that the states created the federal government and not the other way around. But it is true, and we're in a situation today that it seems like the creature has overtaken the creator, and we want to get that straight. And Lieutenant Governor Farris has already very eloquently talked about the proper role of federalism and the relationship to the states and the federal government. I'm sure that Michael Farris will talk about that some more. But I do want to let you know, and I also want to recognize my colleague, Representative Dennis Riddell from Alamance County, standing in the back. He's one of our leaders. I don't know if there are any other legislators here. As I was working my way down Highway 29 from Rockingham County, I saw the handsome face of Representative John Hardister on a big billboard, and I will tell you that he's one of our leaders on this effort as well. But the challenge for us right now in North Carolina is to continue to build support among the legislators. This is something that the legislatures do. Specifically, we need 34 states that will approve this effort. And once we have a convention, of course, any amendment that might be offered would have to be ratified by 38 states, or 3/4 of the nation, in order for the amendment to pass. But right now, our efforts are in North Carolina, so that our state can join the others that are working, and some have already passed a resolution to have such a convention. So one thing that is very important as we build the grassroots effort, contact your legislators, contact your representative, your senators. We need the support so that we can pass this resolution in North Carolina. So with that said, I'm not going to take any more of Mr. Farris's time. Thank you so much for coming out. Thank you for being supportive of this effort and for being informed. And once again, thank you, Lieutenant Governor Farris, for heading this effort. Thank you all very much.
Okay, so this is an educational seminar, if you will. There's going to be a lot of people in this room that have a lot of questions. We'll stay as long as we can to get those questions answered. But there's a lot of content that Dr. Farris will cover. And so write your questions down as you go, and at the end we will have time to answer those questions. You know, a lot of people, as I travel, I talk to media on this topic now a lot, and the biggest concern out there that I hear is about the process. They feel like it can just go rogue and anything can happen, and you know, you can end up having whatever crazy amendments and turn the whole country upside down. And I can understand that fear. And Dr. Farris will talk about that tonight and talk about how we go about doing the process the right way so that doesn't happen. Obviously, North Carolina would never get involved in anything that didn't have a clear process outlined before we got going. So with that, the only really rules we have, we'll be here for a while, and you'll be sitting in these seats for a while. If you have to get up and go to the restroom or step outside, feel free to do that. Make it fairly casual. So don't worry about that. The other thing is, let's just be civil in the room. There may be some very diverse opinions in this room. Direct your questions to Dr. Farris, if you will, and not to other members of the audience when we start doing Q&A. That'll be real helpful for him to be able to answer. And so just write your questions down, and let's keep that fairly orderly. So with that, I'd like to introduce Dr. Michael Farris. Dr. Farris is a man that I've been following for a number of years. He is the founder of the Homeschool Legal Defense Association, in which my family has been members for many, many years. He is also the founder of Patrick Henry College, which I reminded him the last time we were together that we actually have a brick out in front of the college because we were supporting them long before there was actually ever a building there. And I was kind of hoping my kids would be at Patrick Henry, but I have one at Carolina and one at NC State right now. I have 2 left, so I still have an opportunity. But Patrick Henry's doing a phenomenal job of training the next generation to be leaders in this world that we're faced with today. And Dr. Farris's leadership is key in that. He's a constitutional scholar, a constitutional attorney. He has presented in front of the Supreme Court. He's presented in front of the appellate courts. He knows the Constitution forward and backward, and he's a great resource for us to have tonight. He is the coach and leader of the championship moot court team at Patrick Henry College, so he's teaching young people to do exactly what he does on a daily basis as well. And he's also the founder of the Convention of the States Project, and that's why he's here tonight. So without further ado, please join me in welcoming Dr. Michael Farris.
Thank you, Dan. Thank you, Bert. It's great to be here. It's especially great because there's at least 2 families here that have had students that have been a part of my moot court team, and we're really glad to be able to have young people from North Carolina as a part of our program at Patrick Henry College. In fact, my personal assistant right now is a North Carolina homeschool kid that's a senior at PhD right now and one of our champion moot court young people. And has been involved, and there's one of Dan Forrest's personal interns is also on our moot court team. So we've got a real good representation. And the most important thing about my connection to North Carolina, I am the grandfather of 4 North Carolina residents. So that's really just so as long as we're on that subject, I won a college speech contest when I was dating my wife, advocating 0 population growth. I have 10 children and 17 grandchildren. So some things change along the way. We're going to talk about Washington, D.C., what's wrong with Washington, D.C., and how we can fix it. I grew up, my parents got saved when I was 3 years old. I got saved when I was 6 years old. We went to a Baptist church in Washington State, and their friends got together about, maybe 2 times a month for potluck dinners after church. And the men would generally sit outside on the back porch and solve the problems of the world after church every Sunday. First, you start with the problems of the church, and we had host pastor. And then we'd start with the problems of the town and the school system, and eventually solve the problems of the country. Now, I was interested in politics from a very young age, and so I listened to all this, and it just drove me crazy, because while they had good ideas, they never did anything about it. And I wanted to do things about what we're talking about. And so we're not going to just talk about the problems in Washington, D.C., and talk about just writing letters or just kind of doing the same old thing time after time. As you guys have heard a dozen times or more, the definition of insanity is repeating the same process hoping for different results. We have been sending people that we think are the best kind of people to Washington, D.C. for a long time. And I'm all for that. We need to be doing that. We need to be electing good conservatives to the U.S. Senate. We need to be electing good conservatives to the House of Representatives. I hope we can elect a better president. That won't be too hard, actually, next time around. But we, as good as they're going to be, I do not expect Washington, D.C. to ever reform itself. Ever. Because the reality is this. Washington, D.C. loves one thing most of all. The power of Washington, D.C. There is an agreement, a gentleman's agreement, if you will, between the various branches of Washington, D.C. to support one thing. Keep the power in D.C. and grow it as rapidly as is feasible over time. They don't really follow the Constitution as it was originally written. In fact, a lot of people say to me, Mike, why are you worried about the Constitution trying to fix the problems in a constitutional fashion since they don't follow the Constitution at all? Well, that's not exactly the most precise way of describing the problem. Here's a more precise way. There are two constitutions in this country, effectively. There's the Constitution as written by the founders, and there's the Constitution as interpreted by the Supreme Court. And our government actually does follow the Constitution, the wrong one. They follow the Constitution as interpreted by the Supreme Court, that only occasionally agrees with the Constitution as written by the Founding Fathers. And it's, the Supreme Court, two most recent decisions on the Second Amendment. I'm one of the education board committees for the NRA, so you can kind of get the idea of where I am. Good gun control, I'm in favor of good gun control, which means a steady aim, squeeze the trigger, and hit your target. The two most recent decisions on the Second Amendment by the Supreme Court, by a 5-4 vote, mind you, have been good decisions. They followed the original meaning of the Constitution on that subject. But that's the rare exception to the rule. And the problem with our country, the vast majority of the political problems that we're facing in this country, can draw their origins back to the Supreme Court one way or another. And if we would be following the Constitution as written, a whole lot of what's wrong in Washington, D.C. would correct itself. And so the object of the game is not to sit and talk about this like the men did from my family's church in the background, but to find a way to actually do something about it and then go get it done. So that's what we're about tonight. So first of all, let's find out what the problems are in detail and show you why the Constitution and correctly understanding the Constitution and correcting the Supreme Court on these matters is essential to success here. Let's start with the problem of spending. The federal government has no constitutional limitation on the power to tax and spend, according to Justice Roberts in the Obamacare case. Now, I don't want to live in a country where there's no constitutional limitation on the power of Congress to tax and spend. That's not what the founders intended. What they've done is they've interpreted the General Welfare Clause to mean something the Founding Fathers never meant it to be. Now, there was a division between the founders on what the General Welfare Clause did in the Constitution. James Madison and the majority of the founders took the position the General Welfare Clause is not an additional grant of power, but rather it's a limitation on power. When you spend the money that you're authorized to spend, let's say for national defense, you've got to do it in a way that promotes the general welfare, not somebody's private interest. So you're getting somebody rich. That'd be one violation of the General Welfare Clause. Or you're just spending money for some locality, like the bridge to nowhere in Alaska. That would be, it's not exactly military related, but that's an example of spending for a private purpose, a local purpose, that it can't possibly be justified as for the general welfare. Those were the two limitations and understanding. So Madison and the majority of the founders' generation took the position, the General Welfare Clause, not a grant of power, but a limitation of power. Alexander Hamilton and a few others took the more liberal position, but it's not as liberal as is led on today. Hamilton's position was, no, it is an additional grant of power, but it's subject to two rules. Rule number one, same rule as Madison. He agreed with Madison, you couldn't do it for private enrichment, you couldn't do it for local concerns. He agreed on that much. But he said it is an additional grant of power, provided that it's outside the jurisdictional competence of the states. What is it? In simple terms, what that means, if the states can spend money on it, the federal government can't. That's what it means. And that's according to the more lenient theory. Now, he wasn't the only one. George Washington agreed with him. James Monroe agreed with him. A little later in history, Daniel Webster agreed with him. John C. Calhoun agreed with him. John C. Calhoun didn't agree with the modern view of the general welfare clause. You know, anybody can just say John C. Calhoun out loud and have any idea what they're talking about knows he's one of the great states' right advocates of all time. He wouldn't have taken the position the federal government could spend money on anything he wanted. Rather, his position was, if the states are jurisdictionally incompetent to spend money on the topic, then the federal government can. There's only two things in all of U.S. history where there's an actual difference in what the founders believed, at least the examples that I can think of after several years of studying this and thinking about it. One is the Louisiana Purchase, and other purchases like it, the Gadsden Purchase, the Alaska Purchase, and so on. There's no specific power in the Constitution for the federal government to buy land to expand the country. But it certainly meets Hamilton's test. It's clearly for the general welfare of the whole country, not some private deal. And the states can't do that. The states can't expand the territory of the United States. So it passes that test. The other is NASA. The space program is not for somebody's private benefit. It's not a local deal. And it's something, exploring outer space is not really something within the jurisdictional competence of the states. So other than NASA and the Louisiana Purchase, which Thomas Jefferson, who agreed with Madison, thought was unconstitutional, but it was so important he did it anyway, with a guilty conscience. And so that would be the only thing. I mean, it's a very narrow difference of opinion. And frankly, I'd be happy with either of their positions today. Because it's a whole lot different either way than the current position, which is spend money on any fool thing you want. There is no limitation. Ladies and gentlemen, our nation can't survive if the federal government's in a position where you can spend money on anything they want. That's outside the jurisdictional competence of the states. In the year 2020, there's a group called Center for Public Integrity. And just so you know, this isn't some conservative, source that their qualification for writing it is they own a motive. There's a lot of those these days on all sides of the political spectrum. This source is a liberal organization, and I can prove it by citing just one of their board members' names, Arianna Huffington. Okay? All right. The Center for Public Integrity says in 2020, 89% of all federal revenue will have to be devoted to just four things: interest on the national debt, Medicare, Medicaid, Social Security, leaving 11% for everything else the federal government is supposed to do, including national defense. Ladies and gentlemen, our country can't survive that. We are going over a fiscal cliff. We're going into a black hole. Pick your analogy. Pick your word picture. This nation is in deep trouble if we don't stop the problem. And the problem isn't merely borrowing. The fundamental problem is spending. We have to stop the spending. And the way you get spending control is to reenact the constitutional rule that says just this: if the states can spend money on it, the federal government can't. All of the entitlement programs that are bankrupting this country would have to go away. Now, you'd have to do a transition period in any of these programs to be able to keep faith with the people that are depending upon it. But nonetheless, in the long run, our federal government has to stop spending money on things it doesn't have either the jurisdictional competence for or the resources to do it. We've got to stop. Number two, the Commerce Clause. The Commerce Clause, by the way, it was within the last year that I got the best example of understanding the importance of original meaning, language, from a really unlikely source, William Shakespeare. Now, I am old, but I didn't know William Shakespeare, okay? He died a little before, well, he died when I was in kindergarten. So, William Shakespeare's probably most famous scene of all, the balcony scene in Romeo and Juliet, where Juliet cries out, "Romeo, Romeo, wherefore art thou, Romeo?" What was she asking him? Was she asking, "Where are you, dude?" And if that was the question, I never understood why he didn't raise his hand and, "I'm over here in the bushes." It would have been a lousy story if he'd have done that, and had it just made up and everything would have been okay. But it would have saved both their lives. Why didn't he answer her? Well, the answer is, she wasn't asking him, where are you? Because wherefore in Shakespeare's time meant, why are you Romeo? In other words, she was saying, out of all the guys in my city, all the people I could have fallen in love with, why did I fall in love with the enemy of my father? That's what she was asking. And you can understand why a guy, in fact, he's a little young, but he's active. Shakespeare gave him a little more wisdom than perhaps the average teenage kid would have had. But he kept his mouth shut, which is what you should do if the girl you're falling in love with is going, why am I in love with this guy? You keep your mouth shut and you listen, okay? Knowing the original meaning of wherefore entirely changes your understanding of the scene. Knowing the original meaning of the word commerce in the Commerce Clause entirely changes your understanding. Commerce did not mean business. It did not mean economic activity. It meant shipping. Shipping. Congress has the power to regulate interstate shipping, and that's it. Not banking, not agriculture, not manufacturing, not babysitters' wages and hours, not a blessed thing that they're doing under the Commerce Clause except for shipping. The Federal Aviation Administration is a modern example of a very legitimate use of the Commerce Clause power. We're sending planes carrying people and goods over state lines. The FAA is a very legitimate use of the Commerce Clause power. But regulating the wages and hours of babysitters and all kinds of other things, all of the federal regulations of business are unconstitutional under the original meaning of the General Welfare Clause. 100% of them. Does that mean that business should be able to do anything they want? No. It means states regulate business. In fact, the best example of how the states can work together if there's a need comes from banking. Your ATM cards work really well as long as you have money. You can go to a bank anywhere in the country and put your ATM in any place and get cash out. What's the law that makes all that possible? It's not federal law, or else it wouldn't work. Your ATM, they'd still be working on it. It's state law. The states got together and said, you know what? Uniform Commercial Code would be a good idea if we had banking law that was good across all states. And so they got together, they drafted a model code, and all 50 states passed the Uniform Commercial Code. Very modest differences. The differences, they're so modest, your ATM works anywhere you go. Your checks work anywhere you go. Why does it say pay to the order of? It's because state law in all 50 states says, checks say pay to the order of. If the states need together and make a program work that's within the jurisdictional competence of the states, we don't need Congress. The states know how to work together. And banking is not commerce, because the Interstate Commerce Clause power is an exclusive power. The states were prohibited from regulating interstate commerce. So the flip side of that is this. If the states can regulate it, it's not Commerce Clause. It's not legitimate Interstate Commerce Clause power. The federal Constitution was really very savvy. They gave one set of powers to the federal government on an exclusive basis. They gave everything else to the states on an exclusive basis. There have been a couple of very minor things in the history of our country where there's joint jurisdiction. Prohibition resulted in one of those. Because of the 21st Amendment, the states and the federal government have joint jurisdiction over alcohol issues. But that's because of specific language in the 21st Amendment. As that's the rare exception to the rule, virtually everything in our country, the way the founders lined it up, states you do this, federal government you do that. It's much more efficient. It's much smarter. It's much less cost prohibitive. It is the way the government really should work. It's a very smart system, a decentralized system. And all the programs that are bankrupting this country really belong to the states, if we read the Commerce Clause and the General Welfare Clause correctly. You get those two things correct, most of the problems in our federal government go away. Many of them. Two more will correct, and then as long as we're at it. One is, President Obama recently said, if Congress doesn't act, I think it was on immigration actually, that he's got a phone and a pen. Now, I get the pen. He said, I'm going to write the laws myself. I get that. It's not unconstitutional, but I get it. The phone? Is he going to tweet laws? I don't know. I mean, you know, what does the phone mean in that? Is somebody going to call him and tell him what to say? I don't understand. But that, you know, in any event, the most important rule in the Constitution is not the First Amendment. I've been a First Amendment litigator for, almost 40 years. I became a lawyer in 07. And so the First Amendment's very important. But people who say, well, the First Amendment's obviously the most important because they made it first. Well, no, actually not. Congress proposed 12 amendments. The first two just didn't get ratified, so they renumbered. The First Amendment was actually going to be the Third Amendment. The Second Amendment was going to be the Fourth Amendment. They just had to renumber it. So they didn't, but that didn't mean they thought one was more important than the other. First Amendment is very important ideas, but it wasn't intended to be first. And the operative word, the reason you really know it wasn't the most important, is the word amendment. They had to add it to the Constitution a couple years later. The most important rule in the Constitution is in Article 1, Section 1. And the most important rule in any organization is the answer to this question. Who's got the power to make the rules? That's always the most important rule. Whether it's the Student Council at Patrick Henry College, or the Women's Ministry Committee with my church, or the state government, or the U.S. Constitution. The most important rule is who has the power to make the rules. And Article 1, Section 1 says all legislative authority is vested in the Congress of the United States. Congress has 100% of the power to make the rules. The executive branch is not supposed to make the rules. At least not the rules that bind private people and private property. If they want to make the rules, if the president wanted to issue an executive order on the dress code of the Justice Department, fine, he can do that. Rules for the internal operation of the government, that's what they were intended to have executive power over. Not rules relative to my business, my land, my job, my life. Or your business, your job, your land, your life. Those are called laws. And all laws are supposed to be passed by Congress. Why? You know, I was testifying on this issue within the last month in Arkansas. And a legislator there said, well, Congress goes along with this. They give away their power right and left, and they do. In the Obamacare legislation, 2,000 times it says the secretary shall make rules. The abortion mandate that was litigated in the Hobby Lobby case, that wasn't in Obamacare. The secretary made rules mandating Obamacare. Now, the reason Congress can't consent to giving away its legislative power is it's not their power to give away, because they're giving away the right of the people to vote the rascals out. That is the reason we have a Republican form of government, is that we need to have the ability to vote the rascals out. A Republican form of government means this: the people who make the law have to be numerous in nature and have to be elected by the people. You cannot have people making the law at all who are not directly elected by the people as legislators. It is immoral, it is unconstitutional, it is unethical at the deepest level of ethics. So, there are 200 volumes of the Code of Federal Regulation. Books of laws, not laws, 200 books of federal regulations. Every single volume of every single code and title, the whole stack, which would go from the floor to the ceiling at least. Every bit of it is unconstitutional because it violates the rules. Now, let's give you one example. The Environmental Protection Agency, in deciding how wet does land have to be federally protected wetlands, and how much land does it have to be? Could it be, can you throw a cup of water in your backyard, and that's wet enough and big enough? Well, Congress should have passed that, because that's a law. How much land? Those are important legislative policy questions. Why should unelected bureaucrats be making those kind of decisions? So the answer was an acre. Could have been 100 acres, could have been 5 acres. An acre. Supposedly that's big enough to give you federally navigable waters. We have a little creek in the back of Patrick Henry College that runs water about 3-4 months a year. Actually, when there's a good rainstorm, a little water. That was a part-time creek. that creek is federally protected wetlands, and it would not be enough to float a canoe, much less an ocean-going vessel, which is what it'd have to be navigable waters. So we're just going to forgive them for that, because it gets worse. I mean, it really does get worse. They decided, how wet does it have to be? On the wettest day in 100 years, if a goose flies over the property and sees its reflection in the water, that's wet enough. Congress would never vote for the glancing goose test. That's the name of the official name of the test, the glancing goose test. Why? You can hear the ads. Congressman Jones doesn't have the sense that God gave a goose. They would vote the rascals out who made such a stupid rule. When I was the chairman of the regulatory reform committee in Virginia, my committee suggested they didn't do it, but it was a good idea, and still is a good idea. Every regulation by every agency is just a proposal. They've got to submit them to the legislature and vote up or down. Whatever Congress, whatever this process leaves in place for Congress to do, one of the rules should be the agencies don't get to pass final regulations. They can draft them, they can propose them, and Congress has to approve them. They can take up and down votes if they want, but when Congress has to approve them, if we don't like the rules, we vote the rascals out and make the rules. No more hiding behind I don't like that regulation from the EPA either. I'll write them a stern letter. Well, no more stern letters. You either take political responsibility for the regulation or you don't. So, that's problem number 3. We got to go back to all legislative authorities vested in Congress of the United States. Number 4, and this is where Mike Lee coming to town tomorrow is really good. Mike Lee and I led the charge to kill the UN Convention on the Rights of Persons with Disabilities. Not because either of us don't think that people with disabilities should have rights. It's just the first part of that phrase was the wrong part. The United Nations Convention on Persons with Disabilities. Now, I might just mention that there happens to be a Democratic incumbent in North Carolina who votes wrong on those issues in the U.S. Senate. If there are U.S. senators who think that we have to have the United Nations making laws for us on disability policy or other issues because we can't make them ourselves, what that senator is saying is, I don't have the leadership capacity to help make American laws to protect Americans with disabilities. I need the UN to do my job for me. If you're that disinterested in Americans yourself, or that incapable of serving in the U.S. Senate, you ought to do the honorable thing and resign and leave the job to someone else. But I don't want to put this up for an up or down vote anymore. I'm tired of killing these UN treaties. I've been doing it since the mid-90s. And I've killed the UN Convention on the Rights of Persons with, UN Convention on the Rights of the Child. I've helped on other. They lost me at the UN. Because I happen to believe something pretty fundamental. Americans should make the law for America.
Amen.
In fact, that's why the country got started. We didn't want the British Parliament making the law for America. And when we turn our back on that principle, we're turning our back on the very essence of what it means to have a country called the United States of America. That is the most fundamental principle of our founding. Americans make the law for America. And I don't want to have treaty power. I went back to school about 3 or 4 years ago, completed an LLM in Public International Law from the University of London. I was doing opposition research and I got a degree in the process. The professor that taught my course on international rights of the child helped draft the Convention on the Rights of the Child. Little did she know that one of her students was killed at the UN Convention on the Rights of the Child in the United States. I took my exams with a number and not a name, and I was glad for that. And so there is a legitimate place for international law. It's called How Nations Treat Nations. The law of war, trade, piracy on the high seas, boundary disputes. There's a place for international law. It's how nations treat nations. There is no place in international law for how the United States governs its own citizens. And that's what we're doing with all of these UN treaties, is trying to dictate how the United States. I want to see the language of the Supremacy Clause changed. So no longer are treaties the supreme law of the land when they relate to the subject of how the United States governs its own citizens internally. That's got to change. The founders never imagined, even though we need to change their language, we would be going back to their actual intention. They never imagined that treaty power would be used to control the domestic policy of the United States of America. But that's what's happening. The Supreme Court, on multiple occasions, has cited as persuasive legal authority the UN Convention on the Rights of the Child, even though we've never even ratified it. There's an even more insidious doctrine called customary international law. If we had time, I'd teach it to you. But we don't, so you can come to Patrick Henry College and all enroll as students. That'd be great. We'd love to have you all. We have no age barrier as students. But the basic idea is international law shouldn't be used to control our domestic policy. And we can fix that with simple constitutional language. Now, all four of the problems that I've talked to you about can be remedied with about one sentence each in the Constitution. We don't need long, involved things. About one sentence each would take care of it. Just to clarify the original meaning. Because general welfare wasn't the best way in the world to say, if the states can spend money on it, the federal government can't. It would have been better to say it directly. If the states can spend money on it, the federal government can't. And that's what the sentence you need to add. Pretty close to that. Actually, you might throw in the term jurisdictional competence just to make sure that you know you have a law degree. But all it means is, if the states can spend money on it, the federal government can't. And so we could fix all these things. Well, how do we fix those things? And is it safe? How we fix those things is this. The founders at the end of the Constitutional Convention, George Mason in particular, said, we're going to need amendments someday to clarify things, to fix things. Everybody agreed with that. They put in an amendments provision. And they knew we were going to need to fix things someday. They didn't know what they all were. They knew that we'd need amendments. And the proposal on the table was, Congress proposes amendments, the states ratify. Sounds nice and balanced until George Mason raised his hand and said, and I'm paraphrasing obviously, hey guys, what happens when Congress abuses its authority, which I guarantee you is going to happen, he said? Congress, if all the amendments must be proposed by Congress, Congress is never going to propose any amendments limiting its own power. We can't do that. We've got to give the states the unilateral ability to propose amendments to the Constitution. And so Article 5 was written the way it was to solve the very problem that we face today. Washington, D.C. is out of control, and reform will never come from Washington, D.C. That's the reason they wrote Article 5 the way they did. And so here's the process. 34 states have to agree to call a convention of the states. It is not a constitutional convention. A constitutional convention is where you throw the existing government into the trash can and start over. That's a constitutional convention. The correct historical term is a convention of the states. It comes from the very first application ever passed under Article 5 by your neighboring state of Virginia in 1788, after the Constitution was ratified, but before the government started. It was officially filed in May of 1789. The first application called for a convention of the states for the purpose of proposing the Bill of Rights. A couple other things they wanted, but mainly the Bill of Rights. And so that's where it gets its name. It's a convention of states. It's not a convention of delegates. It's not a convention of individuals. It's a convention of states. 34 states have to agree on the convention for a particular purpose. There have been 400 applications for a convention of the states from the state legislatures in the history of the country, including a number from North Carolina. But we've never had a convention of the states because we've never had 2/3 of the states agree on the topic. If you don't agree on the topic, you don't have a convention. There has to be an agreement on the subject matter. And so we have a 200-plus year legislative precedent that is absolutely binding. There is no doubt, zero doubt, in any either political or legal context that that rule is not binding. The states have to agree on the subject matter. Otherwise, they would have to call 12 or 13 conventions right today, because we've got, about, of the 400, probably 300 are still valid. And so, we got way more than enough for a convention right on the books today. You have to agree on the subject matter. The subject matter that we want to call a convention for is this: a convention solely for the purpose of proposing amendments to impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and impose term limits on federal officials. 3 states. I'll say it again. And by the way, we've got plenty of literature in the back, and that formula is on a lot of the literature, so you can get it. But I'll say it again. Is impose fiscal restraints on the federal government, limit the power and jurisdiction of the federal government, and impose term limits on federal officials, which, by the way, could include either Congress and or courts. And of the two, I'm more interested in the courts. Because there is a way to term limit Congress. It's called an election. There is no way to term limit the courts. They're there for behavior. Good, got it. Interpreted out a long time ago. The good behavior requirement. It just means behavior, which means breathing, I guess. And so, the purposes, 3 states have passed the application exactly that way. This year, 2014. Florida, Georgia, Alaska. It was introduced in North Carolina and about a dozen other states. But, in a brand new project like this, it takes a little while to get going. This coming year, our goal is to get it through at least 20 states. And in 2016, try to clean it up and get to 33. Now, if it takes us to 2017, we're not going to cry too much. Because, it's new, but we've got to get going. Folks, we don't have a lot of time. This country is not going to survive. The 2020 deadline is real. It's not something anybody made up. There's a fiscal cliff coming. And if we don't do something about it, we have got a real issue. And so we've got to get going. So we've been building the infrastructure to make this happen in approximately 20, 25 states this coming year. We've got co-sponsors in most of this, prime sponsors and legislative co-sponsors in most of those states. And we are building the infrastructure. We've got a good team. There's about 15 full-time employees working for me in this project. They're scattered around the country, so I don't know exactly. There's 7 in the main office in Purcellville, Virginia. Several of them are Patrick Henry graduates, including our staff council. But we've got a team. We've raised funds. We're very serious and we're going to get this done. My partner in this effectively is the president of Citizens for Self-Governance, which is the organization, the nonprofit organization that's the backbone, the legal structure for this. His name is Mark Meckler. Mark is the co-founder of the Tea Party Patriots. Mark knows how to build grassroots through the Tea Party groups. I've been doing grassroots politics for homeschoolers for 34 years. I know how to build grassroots. We both are lawyers. We understand the legal process. We both know a lot about politics, but we also know a lot about grassroots. And we are convinced that the grassroots matters. And folks, the grassroots is almost all that matters. You've got to have leadership. I mean, the fact that Lieutenant Governor Dan Farris is here tonight, that is huge in this state. That is huge. Leadership like that, courageous leadership like that, first of all, needs to be praised and encouraged. And secondly, you have to acknowledge that it's huge. But the reason you got to be a leader is because of grassroots. And grassroots are what's going to deliver this as well. Because without the grassroots, we don't get to 34 states. But with the grassroots, I guarantee you we get to 34 states. And then I guarantee you we get to 38 states ratified. How do I guarantee you that? It's as simple as this. Government always works on one principle. The majority of people that stand up, speak up, and show up win. That's the way it works. And in an election campaign, you've got to have the majority of those who register to vote and vote. That ends up being around 25, 26, 27% of the population. It's never a majority. It's the majority of those that stand up, speak up, and show up. Now, in our activity, this is lobbying. This is state legislative lobbying. It's encouraging state legislators to do the right thing. In that context, 1% of the population is way more than ever contact the state legislators on any one issue. On average, in state house districts nationwide, 1,000 people is about 1%, or actually is more than 1% of the population of that district. Way more. Okay? 1,000 people who call their state legislature and say, I want you to support a convention of the state. I guarantee you that will happen. Now, if 100 call, probably. I spoke about this to the Speaker of the House of Virginia this year. And he told me, Mike, I had a legislator complain about how many calls he got over an issue. And he said, well, how many calls did you get? He said, 6. 100 is an incredible number in a state legislative context. My goal is a minimum of 100 in grassroots activists in 75% of the districts of 40 states. That's 3,000 districts. That's 300,000 people. That's 1/10 of 1% of the American public. It is probable we can save this country with 1%, 1/10 of 1% of the American public in 40 states. With 1%, when I'm at 1,000 per district, which is 3 million people nationwide, I guarantee you we'll win. Are there enough people who believe in freedom in this country for us to win? People go, oh, there's not enough people who believe. We've lost it. No, we haven't. Because all you need is 1,000 people. You just need the 1% who will stand up, speak up, and show up. And if we're the ones who stand up, speak up, and show up, we're going to win. Because there's a big divide in this country, and the big divide goes like this. What's the purpose of government? If the purpose of government is to provide for my needs, you believe in socialism. And socialism and freedom are utterly incompatible on the long haul. The other answer is, the purpose of government is to protect life, liberty, and property and punish those who do evil. If you believe that, then you believe in freedom. You cannot have it both ways on an extended basis. It just doesn't work. And so we need to, before our country succumbs to the purpose of government is to provide for my needs, we've got to save it for those who believe the purpose of government is to protect life, liberty, and property. Because freedom's for everybody. Freedoms for everybody include those who think the purpose of government is to provide for my needs. And in the long run, they think we'll be better off if the government's providing for our needs. In the long run, we think that they'll be better off if they live in a free country, where there's economic opportunity, and where they can get a job, and they can provide for themselves. Thank you very much. That's the dispute we're in. But the mechanism is the one we've outlined. We need to do this. Why is it safe? It's safe because you can't have 34 states agree on the topic. That's barrier number one. Barrier number two, you've got to have 26 states at the convention to agree on the specific language of an amendment, a balanced budget amendment, a spending limitation, fix the general welfare clause amendment, a commerce clause amendment, term limits on judges amendment, a term limit. By the way, I think the Supreme Court should be appointed by the states, not by the president.
Amen.
And so, real checks and balances in this country. So, those kind of, the details of the amendments, nobody can promise you exactly what the details will be, because that's what gets done at the convention. You've got to have a convention on the subject matter. The question is, can they change the subject matter? No, they can't. Why? Because it's unconstitutional, it's illegal, and we got the votes to stop it. What are the chances of me being appointed by President Obama to the next vacancy on the Supreme Court? Nil. Exactly. Why? Why do you say that? You can count, right? You know political reality and you can count. I am fully qualified to be on the Supreme Court. If Bobby Jindal, other Republican, who's a friend of mine, gets to the Supreme or president, Bobby might actually think about appointing me to the Supreme Court. It won't ever happen because both Bobby and I know I can't get confirmed in the U.S. Senate. Why? Because I actually believe in the Constitution. And so if you believe that, you're not ever going to get confirmed to the Supreme Court under the current system. And so we're realists. We can count. We know we can figure political reality. If you can figure political reality like that and you can count, here's the reality. 27 state legislatures are controlled by Republicans in both houses. 6 more states are controlled by Republicans in one house at least. That means 33 states have a Republican, at least one Republican House. To ratify something bad, you've got to get 38 states to ratify. You've got 17 Democrat states. Let's just pretend that the Democrats will all vote bad. I don't think that that's justified, but let's just pretend it. Okay? 17 states, the Democrats vote bad. They got to get 18 states out of the Republican camp to vote. 18 out of 33 states. That's a hard road to hoe. In fact, it's the same exact possibility of doing that as me being confirmed to the Supreme Court of the United States. I can count to 51 votes in the right scenario. You got the rule on cloture, you got all kinds of other things. It's politically impossible to get me appointed to the Supreme Court. If you just have half a dose of common sense, you know, we've got the votes to stop anything bad. Secondly, I've already litigated this question and won. In the late 1970s, Congress tried to change the rules for the ratification of the Equal Rights Amendment. I was a very young lawyer when I did this. I wasn't 19, I was in my 20s. About 25 years old. And I challenged the constitutionality of Congress changing the rules for the ratification of the Equal Rights Amendment. It was originally 7 years, they added 3.5 years to the process. On behalf of 4 state legislators in Washington State, I filed the first constitutional challenge. My case got consolidated with a case that got filed a little later with legislators from Idaho and Arizona. 3 states worked together and we won. And the holding was this: you can't change the rules in the middle of the street. So how do I know you can't change the rules in the middle of the street? Been there, done that, won the case. I even argued one aspect of the case in the Ninth Circuit, and I won that in the Ninth Circuit. So it wasn't that exact point. The point was there. In the Ninth Circuit, the issue was the National Organization for Women tried to disqualify our federal district judge, who was a high-ranking member of the LDS Church. And they said because his religion opposed the Equal Rights Amendment, he should be disqualified as a judge. I argued that in the Ninth Circuit, and we won in the Ninth Circuit. And Senator Sam Ervin wrote me a letter congratulating me on my brief in that case, which is one of my lifetime prized possessions. And so, been there, done that. I won the issue, and we can win again. I have no fear of any of these things. Ladies and gentlemen, if we're going to think about what should we be afraid of in this process. Washington, D.C., what is the likelihood of Washington, D.C. spending us into oblivion? What's the likelihood of Washington, D.C. continuing to spy on American citizens? What's the likelihood of the president continuing to legislate without authority? What's the likelihood of them continuing to use treaties to regulate the domestic policy of the United States? What is the likelihood of all those things? It is 100% in every single case. If we're going to, that's not fear, that's just rational thinking and saying, that's what's going to happen. We don't have to be a prophet or the son of a prophet. I'm a Baptist, an ordained Baptist pastor, and Baptists can't do prophecies in Rule Book 47. And just to put an exclamation point on it, I've been running nonprofit organizations for over 30 years. So I am not a prophet. I am a non-prophet. That is not prophecy. That is just plain old look at the reality and make a reasonable prediction, which is what lawyers have to do for clients all the time. You say, here's what's coming, here's the facts, here's the reality, now make a decision. Well, folks, the people that say this is going to be a runaway convention and all this stuff, I debated the John Birch Society in Oklahoma over this, and they had ideas on how to fix it. One was nullification. And I said, how are you going to nullify all 200 volumes of the Code of Federal Regulation one at a time? That's like getting in the, you remember Indiana Jones' knife fight with the big Egyptian? Okay? Don't get in a knife fight with the big Egyptian. Try to nullify one law here, one law there. No, that'd be like, switching analogies, that'd be like playing whack-a-mole. Just as soon as you try to nullify one in one state, first of all, the federal court's going to say the nullification was invalid, and then secondly, they'll pass another one just in its place. Whack-a-mole, whack-a-mole, there's no end to it. You pull the pistol and you shoot the big Egyptian in the gut, which is you take away the power of the agencies to make laws at all. That's how you solve that. You can't. The states have the power of nullification, but it's not a single state. It's the states. You nullify their claim to constitutional authority, and the methodology is Article 5. That's how it works. It's not through some, pretentious idea of nullification, some other theory. Other theories don't work. This is written in the Constitution, and this works. And so I asked the John Birch Society, when you figure out that that plan won't work, why don't you come join us and help get Article 5 passed, the Convention of the States? He said, no, if nullification doesn't work, the right answer is secession. And I said, you mean you'd rather deliberately destroy this country out of fear that something bad might happen to the country than to take a chance, so-called chance on Article 5? He said yes. Ladies and gentlemen, I don't want to destroy the country, and people who think like that think dangerously. They mean well, and they really do mean well. But really, here's the best analogy I've come up with for such people. It's like the guy that intercepts the football and runs the wrong way and scores for the other team. When you intercept it, you did a good thing. You mean well. He meant to score for his own team. But when you're running the wrong direction, you're running the wrong direction. Your intention doesn't matter. It matters what you're doing. And people that are out there advocating for secession, they're running the wrong way. We got to preserve this country, not destroy this country. I debated Andy Schlafly, Phyllis's son. Phyllis and I have been friends for a long time. Phyllis has only made one political mistake in her life, and it's on this issue. Other than that, I think she's got a perfect record. Everybody's entitled to one mistake. That long, that's a really good record. I'd like to have that batting average myself. I debated her son on this issue. Andy's a lawyer, he's my age, and I said to Andy, Andy, you admit that Article 5 is in the Constitution and it could be used under the right circumstances. What are the right circumstances? And he said, well, if the president declared martial law and took over our country and ruled it as a tyrant then. I said, Andy, if the president declares martial law, there's only one response then. It's get your guns, boys. Let's go get our country back. It is too late for using constitutional processes when they've declared martial law. I don't want to wait for a secession movement. I don't want to deliberately destroy this country. And I don't want to put my head in the sand until somebody declares martial law against us.
Amen.
We have got to do the right thing, and we've got to do it now. Not on our watch. Not on our watch. And I don't want some outlandish theory of fear to be the reason we didn't use the very solution the Founding Fathers gave us. So, it's time to act. And I would love to answer your questions. But ladies and gentlemen, when we get done with the questions, I want you to be willing to come help me. Because this is not just a discussion for the sake of discussion. This is an education so that you will help me get going. Yes, sir.
I'm Les Creeks. I've been in Guilford County. I ran for school board in 1994. I got pretty upset with the comprehensive sex education and forcing things on my kids that I didn't agree with. That's not general welfare. That's abuse. I would say that if we had a guy like Sam Ervin, who was U.S. Senate, who's a Democrat, now we'd have a man removed from the presidency right now. We probably would have had one in the 1990s with Bill Clinton with what went on there, because he wouldn't have allowed all the obfuscation. So we'd have had an impeached president and a removed president 2 times in the last 24 years. I appreciate all you've done. I followed what you've done for the last few years, especially the college in Virginia. I think it's great, and I think you're very sincere about what you say, but to broad brush the John Mercer side and the Phyllis Schlafly that we have without being here is a little disingenuous. I would say we don't have men in this country who care about it like you do in the majority. Like we had the Sam Ervin, we'd have no problems with the White House because they got rid of Nixon, they would have gotten rid of Clinton and Obama. If you think that you're going to run it like grassroots campaign under the radar with the Constitutional Convention, however you characterize it, and I've studied it for a long time, I'm with the John Mercer side of this. They've laid out, you want all the facts about what can happen. You can't hogtie. Once that convention meets, it's Katie bar the door. If you think George Soros and Microsoft, Bill Gates, and those guys won't throw their money, and that the labor unions and all the other people across the country won't show up to change what's happened at the Constitutional Convention, you've got another thing coming. And I would also say, right now, yeah, you've got 30-some states that are legislatures and governorships are controlled by Republicans, but the pendulum swings in wild fashion. In a presidential election, we probably will end up with Hillary Clinton in 2016. I figured when I saw Barack Obama running, I told several people he'd be the next president because of the nature of the body politic in America's disease. When fewer than 38% of the American people even know that we have separation of powers, they don't even know what it is. That was a recent Vox poll.
Sir, you're going on too long.
Is there a question?
Sir, please sit down for a moment. If you need to ask me a follow-up question, you can. I'm 63 years old and I can't remember everything you said. I just want to chance to let me respond, and then if you have follow-up questions, you can have a follow-up question, okay? All right. I just can't remember it all. All right. So let me go with the stuff that I can. First of all, if you want to see a full and fair debate with the John Birch Society or Andy Schlafly, go to our website. It's up there. You can watch the whole thing. Secondly, they are out doing these kind of meetings all the time. They don't invite us. And so they, just because one side's represented in one night, it doesn't mean either side's being unfair to the other. It's just, that's the way things work, and not every time do you go out and do debates. Sometimes you do educational community, but if you want to debate, you can go watch my debate with them. Everybody can go watch it and see it for yourself. Number three, the George Soros and all those people, they have power in Washington, D.C. They are advocating that we should elect U.S. senators that support their view. We don't go and say, well, we shouldn't elect U.S. senators because George Soros thinks that we should elect U.S. senators. No. We want to elect our people, and he wants to elect his people. It's called ordinary political process. And just because they want to participate in the process, let them. I'm not afraid of George Soros. I'm not afraid of the teachers union. Let me give you an example. 34 years ago, I started Homeschool Legal Defense Association. The teachers union is the most powerful political organization in every state capital. Who did I represent? The tiniest little education group in the country, homeschoolers. We're about 4% of the population today. We were about as big as my family's 15-passenger van in 1984. There wasn't very many of us. And we went state by state by state, doing the right thing, out hustling, out working them, and we beat the teachers union consistently, state after state after state. Why? Because we're so good? No. Because we did the right thing, we depended on the power of God. And I'm not afraid of the teachers union anymore than I'm afraid of I'm not done answering your questions. I have proven that I know how to do this. I know how to reverse the Supreme Court of the United States. In 1990, the Supreme Court made a ruling called Employment Division versus Smith, where they threw the free exercise of religion into the constitutional trash can and said no longer does a person get to have a religious exemption on a constitutional basis from a neutral law of general applicability. What that means is my Patrick Henry College would never hire a homosexual professor. If one got through the cracks somehow, we'd fire him the next day that we learned about it. If there was a gay rights law in Virginia, which there's not, but if there was, we should be able to have a constitutional defense to that, say we should be able to set our own dictates, not according to the Supreme Court in Employment Division versus Smith in 1990. Well, there was a law passed called the Religious Freedom Restoration Act. I'm the guy who named it. I'm the chairman of the group who wrote it. And I got it through in a Democratic-controlled Congress with a coalition that looked like the original bar scene in Star Wars. The ACLU was there, People for the American Way was there, and others. But we stood up for a principle, and that is religious freedom for everybody. And we passed the Religious Freedom Restoration Act. When Hobby Lobby won its case in June last year, it was on the basis of the Religious Freedom Restoration Act that I named in 1991 when it was passed. And the case out in Idaho, where the two pastors are being told they're going to have to perform same-sex wedding, the Idaho Religious Freedom Restoration Act is what's going to save their bacon. And I was involved in helping that get going, the state-based RFRAs. And so, let the John Birch Society say what they want to say. They don't know what they're talking about. When I was debating the John Birch Society representative in Oklahoma, one of the questions from the audience to both of us was, what amendments would you propose if an amendments convention were held? Well, that question was directed at me, but we both had to answer it. And he said, well, I suppose I'd want one of the amendments that was proposed by the original ratification conventions, where not only should you have a jury trial in criminal cases, you should have a jury trial in civil cases. So I pulled out the Seventh Amendment and read it to him. Said, you have a jury trial in all cases where the amount's over $20. I said, $20 a problem to you? Well, you think we've got $19 cases out there that not having jury trials for? He didn't know the Seventh Amendment existed. And it's not enough to kind of know the Constitution. It's not kind enough to know. I have personally held in my hand the original ratification documents of every single constitutional amendment from the 13th Amendment forward into modern times. You show me one person from John Birch Society. Their chief lawyer is no longer a lawyer. He's lost his license to practice law. And so, Who's on my side? Robbie George, Princeton Law Professor, the chief pro-life lawyer in the country. Bob Chuck Cooper, the chief outside counsel for the NRA, who was the #3 Justice Department lawyer for the Reagan Justice Department, the Office of Legal Counsel, Office of Legal Policy, rather. C. Boynton Gray was White House counsel under Republicans. John Eastman, U.S. Supreme Court law clerk, who's a very conservative guy, who's the chairman of the National Marriage Project. He's on my side. He's a law school dean and professor. There's all kinds of people who have conservative credentials, arrows in our back, victories under our belt, people who have done this time and time again, whose conservative credentials cannot be challenged. 2 years ago, the John Birch Society called me a constitutional champion. Phyllis Schlafly gave my wife the full-time homemaker of the year award. I've been on the right side of these issues for a long time. And because I disagree with them on one issue, suddenly I'm George Soros' best friend. And the defamation that they have done in state legislatures against me, the defamation they've done against my friends, alleging that we're taking money from George Soros, it's outlandish, it's defamatory, and up with wit I will not put, to quote.
I wasn't saying that you...
I want a question, sir. If you want to make a speech, get your own audience. If you have a question.
Why aren't you going after like the 17th Amendment or...
The 17th Amendment is, repealing the 17th Amendment is germane under our application. Mark Levin, who advocates repealing the 17th Amendment, among many others, is on our legal board of advisors. He endorses the Convention of States. It's on our target list, sir. Yes, sir.
Before I ask my question, how many people in this room know that a federal judge upheld the marriage amendment, Puerto Rico's marriage amendment, 1 week ago? Some people know. What is it, 3%, 2%? Here's my question, and it's not your fault. But anyway, what's the ramification of this fact that he upheld it, and I believe Louisiana's was upheld,
Yeah,
right? There were
right.
2 of them, right?
Okay. How much time do we have? Let me answer the question narrowly, and then let me see how much time we have to answer it broadly. The Supreme Court turning down review of a bunch of cases on the first Monday of October, the opening of the term this year, is very bad news. And what it does effectively is to legalize same-sex marriage nationally. And it's just going to be done, blink, 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 blink. The Puerto Rico decision will be appealed to the First Circuit Court of Appeals, which is headquartered in Boston. Need I say more? And so the idea that, so the Supreme Court doesn't want their fingerprints on this, but in the case of Lawrence versus Texas, when they said the states no longer can outlaw sodomy if they want to. Nobody was actually punishing people for sodomy. It was just a matter of a standard of right and wrong that was useful in other cases, like a divorce case where you've got one person doing one kind of behavior and another person not doing that. You lose all kinds of things as derivative matters. But nonetheless, Justice Scalia, in his dissent in the Lawrence versus Texas case, said this: if you don't know that they've just legalized same-sex marriage, you don't know how to read Supreme Court decisions. That's what has happened. The Supreme Court has de facto done that. In 1995, I was in a meeting at the Dallas airport with the top conservative Christian leaders in this country and advocated that we push for a federal marriage amendment right now before it's too late. And they said, Mike, you've got a solution in search of a problem. When the problem is acute, then we'll deal with the issue. We waited too long. And then when we got to the point, we chickened out, and too many of the so-called conservative leaders tried to put in a provision that would allow civil unions into the Constitution of the United States. As long as you didn't call it marriage, you can give them 100% of the right of the spouse. That's what conservatives were advocating. Craziness, absolute craziness that God would never bless. So we shot ourselves in the foot. How the process that I'm talking about today could help us is indirectly. We've got to get control of the federal courts. And the only way to get control of the federal courts is to change the method of selecting the federal courts and putting them under term limits. Have the states pick the federal judges, at least at the Supreme Court and the federal district court level. Maybe you let the current system pick the Court of Appeals judges as a balance. You have some judges pick one way, some judges and pick the other way. But we've got to get some real control on the judiciary, or else this kind of thing is going to keep happening. I hope that North Carolina, and Dan Farris has been doing remarkable leadership on this issue. I hope that North Carolina can figure out a way to get its issue before the Supreme Court of North Carolina so that there is a real conflict where a state Supreme Court rules the right thing and forces the U.S. Supreme Court to deal with the issue. That will help us get political focus and be able to get the thing done. I have little hope that the Supreme Court will do the right thing. But when they rule it directly rather than this little by little thing, then the political ramifications will be a lot different. Yes, ma'am.
A convention would plunge us into chaos and controversy to the interpretation of what the Constitution actually says. Who would
Why?
Hold on. Who would be
No.
Who would be the authority to interpret what the Constitution actually says? Number one. Usually, all conventions, they break the rules, and the guy with the gavel is the one who determines who gets recognized, who does not get recognized. They turn off mics. They don't play by the rules. So my question to you is, how would the authority for this convention be selected? The delegates, how would they be apportioned and be determined? What would qualify a delegate?
Okay.
So this is my concern of not being able to muzzle the actions of a new convention.
Okay. Who appoints the delegates? The state legislatures appoint the delegates. How many do they appoint? Whatever they want, because it's one state, one vote. So you caucus, each state caucuses, one state, one vote. There have been 32 conventions in the history of the country, 32 conventions in the history of the country, about 2/3 before the Constitutional Convention. The rest after, none under Article 5 specifically, but multi-state conventions for drafting various documents. And of those, every single time, it's one state, one vote. Why? Because that's the nature of a meeting of sovereign states. It is a convention of states. 34 states, one state, one vote to call the convention. 38 states to ratify, one state, one vote to ratify. 26 states, one state, one vote at the drafting of it. It's one state, one vote at every point of the process because that's what the founders intended. They wanted to give the states. They're not sending delegates who have individual votes. They have a vote as members of a state delegation. They caucus on each vote. They probably will do it electronically, but they would caucus on each vote, and whoever carries a majority of that state's votes on a particular issue would do it. The Assembly of State Legislatures, that Delegate Jones is a part of, are writing the rules in advance so that we have the details. But the two details that we really need to know, we already know the answer to. The one is, how do you vote? The answer is one state, one vote. And the other question is, can you change the rules? No, you can't change the rules. We know that. We know that.
It happens.
Oh.
In every convention.
Okay. There's a difference between a Republican convention and a convention of states. There have been, there is. A convention of states is the same as a drafting convention for a treaty. That's what it is. There have been thousands of drafting conventions for treaties in the history of the world. It's a meeting of state sovereigns. In international law, they call nations sovereigns. There's never been a successful convention in the history of the world where the subject matter was changed. Never. It's never happened. Because when states meet as states, there's only one way it goes down. It's one state, one vote. Anything else is a violation of the most fundamental principles of human rights and dignity. It's never happened. So I don't care what's happened at a particular Republican convention. It's an irrelevancy. The relevant fact is we've had 32 multi-state conventions in the history of the country, and they've all gone just fine, thank you very much. And they've never changed the subject matter. They've never changed the rule on one state, one vote. Now, I thought where you were going to go, and it would give me an opportunity to teach you all the truth about the American history. Have you ever heard that the Constitution was a result of a runaway convention? They were supposed to go there?
Yes, sir.
Okay, did you believe that?
what I've read, yes.
Okay, let me teach you the truth, okay? We shouldn't get our history from the Common Core.
Amen.
If you want to defeat the Common Core, you take away the power of the federal government to ever mess with education again. Okay? So, the allegation that they were supposed to only amend the Articles of Confederation comes from a resolution passed in February of 1787 by Congress, the Congress under the Articles of Confederation. Now, if anybody knows a lick of anything about the Articles of Confederation, you should know this. There are no implied powers of Congress under the Articles of Confederation. They had only explicit power. There's absolutely nothing in the Articles of Confederation about calling any such convention. Congress didn't call the convention. What it said, in fact, that February of 1787 resolution said, is Congress is of the opinion that it would be expedient to have a convention on May 1787 in Philadelphia. Well, why wasn't that a de facto call? The reason was 7 states before that had already called a convention. So Virginia was first, New Jersey was second, and after that, 7 more states called a convention, named their delegates by name, gave them their instructions, told them what to do, told them what they were there to do, and here's what they were told to do. Quote, render the federal constitution adequate for the exigencies of the Union, end of quote. There was no runaway. They went there to render the federal constitution adequate for the exigencies of the Union, appointed with the authority of the states to do it, and they did it. Now, 2 states, after Congress did their thing, followed Congress's language, where they said both render the federal constitution adequate for the exigencies of the Union and only amend the articles. So 2 states' delegates went with mixed messages. New York's delegates went home because they didn't think they could obey it. Massachusetts, which was the other of the 2 states, they thought they could obey their instructions, and they stayed. Madison and Federalist 40, you want to read the original thing on this, go read Federalist 40. Madison tells us why he thinks that the Massachusetts delegates did the right thing. But that's a historical footnote of some interest to historians as to whether the Massachusetts delegates did the right thing or not. It doesn't undermine the legality of the convention whatsoever. Then people say, oh, well, maybe they didn't run away at the convention level themselves, but then they violated the rule that you had to have 13 states ratified. Well, no, wrong again. Again, don't read the Common Core, don't read secondary sources, read the original documents. Here's what happened in the original documents. You can go read that. Number 1 is the source of law was not the Articles of Confederation. They were operating outside the Articles of Confederation. The Articles of Confederation said any amendments had to be approved by Congress and all 13 state legislatures. Why? Because it was effectively a treaty among sovereign nations. And that's the way you always do it when you're in a treaty among sovereign nations. 10 of the state resolutions calling the delegates, the very thing that gave them their authority, said exactly the same thing. Send it to Congress, all 13 states have to agree. So that was the rule, but not because it was in the Articles of Confederation, but it was because it was in the state documents. And it was the inherent rule of states as states meet. That's how it had to be. So what did they do? They sent the Constitution from Philadelphia to New York where Congress was meeting. Congress approved 2 things. First, it approved the Constitution, well, simultaneously. They approved the Constitution itself, and they approved the new process for ratification. They didn't send it to the ratification conventions. Philadelphia didn't send it to the ratification conventions. The Congress didn't send it to the ratification conventions. They sent it to the state legislatures to ask the state legislatures to agree to the new process. All 13 state legislatures agreed to the new process by passing calls for the convention. North Carolina, being a really important example, North Carolina legislature called a convention for ratification, thereby approving the new process, and then the convention tabled the Constitution itself because there was no Bill of Rights. And so, while it effectively defeated the Constitution, North Carolina didn't participate in the first Congress. Had no representation, weren't part of the Union. Didn't vote for George Washington in his first election because you didn't agree. And when the Bill of Rights was proposed, then North Carolina ratified and you rejoined the Union. That's what happened. And so you can't force a state into a new thing without its consent, but all 13 state legislatures agreed to the new process. It wasn't illegal at any stage. If all 13 states agree to a new process, they agree to a new process. If all states wanted to agree to a new amending process, they could agree to the new amending process. You have to get them all to agree before it would be effective. That's what happened. We've never had a runaway convention. And the arguments of the John Birch Society and the Eagle Forum on this, they continue to defame the Constitution and the founders itself by continuing to argue it was an illegal runaway convention. I can forgive a lot of things, but I can't forgive defaming the Constitution itself. It was lawfully adopted. Saying that you're a constitutionalist, yet believing the Constitution was unlawfully adopted is like saying George Washington was a great American hero, but you know what? He was also a British spy. You can't have it both ways. Yes, sir.
My name is Paul, and I'm with Johnson County. I'm a little bit of an enigma. I actually work for the Department of Public Instruction.
Great.
I don't make policy. I'm also a member of HDO.
Wonderful. Great. Glad you're here.
And I don't have kids. Long story.
Wow. More power to you.
Yeah. My question is really germane here. So
Okay.
last question. I wrote it down, so I won't.
Okay.
You've heard to have significant confidence that this will not be a runaway convention. I trust that you've heard the military principle. No battle survives contact with the enemy. Those who oppose this effort have been accused of, among other things, being afraid. Frankly, I'm not a fan of FBI. You said the only thing we need to fear is fear itself. I believe a little fear is healthy, especially when we're talking about performing surgery on the foundational document of our nation. Instead, I subscribe to Andrew Jackson's and later Patton's never take counsel with your fears. Fear is okay, provided you're not driven by it.
Okay.
So my question is, and there's 4 question marks, but it's really one question.
Okay.
Have you considered the possibility that the stars may align against us and the progressive do get control of this nation? Has God never let nations and people spend time in their wilderness? Say that happens and we're saddled with FDR, our Second Bill of Rights. What do you think that could trigger in this nation, already as divided as it was in 1860? And are you prepared for that contingency?
Well, I appreciate the manner of your question, and here's the basic answer. I have studied this in depth, and I don't think that truisms, either don't interfere with fear itself, or I don't think that nothing ever survives a battle. I just don't guide my life by truisms. If I'm going to use a slogan to guide my life, it's going to be found inside the pages of the Word of God.
Amen.
And so human truisms are, they're okay. But the reality is, I've been in the political trenches for a long, long time. I've fought these things out for a long, long time. I fought for homeschool freedom, and I've won. I fought for religious freedom, and I've won. I haven't won every battle I've ever been involved in, by any stretch of the imagination. I have a consistent record of over 30 years of fighting these things and winning. You win some, you lose some. You've got to pick your battles carefully. You've got to pick battles that are possible. My basic argument to anybody who represents the kind of issues that your question is concerned about is this: there's no alternative. There is no alternative. Let's work hard and go elect more conservatives to Washington, D.C. That's not going to happen. The Speaker of the House, the number 2 guy in the House of Representatives, is giving it interviews over the last week, talking how the Republicans in Washington, D.C. need to move left to govern. And so that's what they're saying in advance of the election. If we think that it's going to change in Washington, D.C., we're crazy. Giving up's not an option to me. Burying my hand, saying that American people are not good enough. We don't have enough people who believe in truth. And I don't believe any of that. I believe that inside the hearts of enough people in this country who believe in freedom, that there are enough of us who can stand up, speak up, and show up, and we can win. I believe that not only as a matter of faith, I I believe that is a matter of long experience. And so, yeah, I mean, I have to take those things into consideration, but I think the best analogy I've given is not the slogans that anybody says, I don't care who they are. The best analogy I've given you is, what's the chances of me being ratified or confirmed as a justice in the Supreme Court of the United States? I mean, it's possible, and it's theoretically possible, but it is utterly unlikely if we just have a half a dose of common sense. And I think that the same answer is true of all the fears that anybody has. Yes, sir.
Dr. Farris, I'm Chuck Bino from High Point. My question I have really is a two-parter. You mentioned Mark Levin earlier
Yes.
this evening. Would you suggest his book, Freedom Amendments, like I think it was called?
Liberty Amendments.
Liberty Amendments, or do you have something that you have published yourself that might help us on this matter a little bit more?
Mark's book, The Liberty Amendments, is excellent. I would encourage you to read it. It is not identical to our application because there's one amendment there on property rights that would have impact on state governments. And so we're not doing anything that would impact state governments. So 10.5 of his amendments would be germane under our application. But none of them are guaranteed to be passed. And Mark knows that. Mark would tell you, as he's told me face to face, he would like to make a couple tweaks to some of his proposals today. And so those are the kinds of things that can be discussed and decided. If you want further information, you can go to our website. We have got so much information on conventionofstates.com. We've got a 300-plus page legislative compendium. If you want to read the arcane details of how we know the rules are safe, you can read 300 pages of legal treatise and just immerse yourself into the details. Mark Meckler and I are in the midst of writing a popular book right now. It should be out in a few months that gives more of the battle plan kind of thing. But there's a ton of information on the website. There's videos, there's more information than you can possibly imagine. Let's turn to the back of the room.
Thank you for coming. I'm Buddy King. My question is this. We already have Article 1, Section 1. We already have the 10th Amendment. And we already have delegated those powers. What I see is we need backbone from our governors and legislators to stand up and nullify those laws. Like especially, the President said over the airways, it's my pen and telephone. And he passed that, or initiated the DREAM Act. Why is it for the illegal kids to become citizens? Nothing is stopping that. When are we going to have the courage to say no? Not in my state. They dumped 2,000 down in Charlotte. The trafficked kids up that were trafficked up here. How can we stop that? If we can't stop these unlawful things now, how are we going to stop new legislation or amendments to the Constitution?
Hold them accountable.
No, just a second. I got to do one at a time. This isn't tag team wrestling match. First of all, there are 3 aspects of good government that are relevant here. One is good people, good policy, and good structure. The arguments for the conservatives have focused on for a long time basically are just good government and good people. Let's elect the right people, let's get the right policies in place. The argument, why don't we have people with courage at the state level who will do all these things? There's complicated answers to that. When I ran for Lieutenant Governor of Virginia in 1993, won the nomination, my running mate, George Allen, got elected. I was out campaigning on not going along with the precursor of the Common Core. And George, to his credit, when he was governor, refused to take the federal funding for that. He got the living daylights beat out of him by the Republicans in Virginia saying, we're the only state doing it. And so the Republicans eventually caved in because it was a one-off strategy. Is not the way to beat the federal government. You get picked off one at a time, and you get good people like George Allen made to be put in an untenable situation. And so, the reason I say that nullification is not a viable alternative, I don't even want to debate the legal theory of it, it's just the viability. How do you nullify the national debt? How do you even conceive of doing that? How do you nullify, all the federal spending? You can't do it. I mean, even if nullification was possible, which is legally, I just guarantee you, every federal court that's going to deal with it is going to declare the Nullification Act unconstitutional. It's going to be a question of whether the governor will call up the National Guard to fight the U.S. military. It leads to war. It is an act of war, and we have to decide whether or not we're willing to take that. I'm not in favor of declaring war when the Constitution's right in front of us and it tells us a process. And it tells us a process that we can use that's perfectly peaceful and lawful, and it's written in the Constitution. And so there is no alternative. There is no alternative. Nullification is not an alternative. It won't fix this federal, how are we going to nullify the federal judge's rules on same-sex marriage in North Carolina? That is a very, very difficult thing. And so, the federal magistrates will come to the offices and they'll arrest the clerks if they don't comply eventually. And so the question is whether the governor would call out the National Guard and we go to war over the issue. We can either go to war or we can use the Constitution. Those are our real choices. Yes, sir. In the back of the hearing.
Appreciate who you are and what you've done. I am concerned a little bit about the convention, but I'm more scared about those who talk about the problem and do nothing. But I'll have to tell this good number that's here tonight that you need to be scared. But the problem is we're not going to the source, sir. The source of is which you have identified is the Lord God Almighty, which is identified by declaration and by the Constitution. But I have yet to see a church who's really scared about what's going on that calls the church to pray, and that's what the Bible calls us to do. God said He will heal our land if we repent, the church, repent of our sins and turn back to Him. So I ask you, every one of you, that you would go back to your church and you petition your church, your pastor, your deacons and all, to call for a convention in the church for prayer and fasting. Then we can turn, God will heal our land, and this can be the solution. But if we take this as the solution without going to God, this, as good as it can be, will fail. I promise you, this will fail, sir. But I thank you, sir, for what you're doing. And I am behind you.
Thank you very much. I agree with you in 2 ways. Number one, unless the Lord builds a house, we labor in vain. Number two, this is not the solution. This is a means to freedom. Freedom will always have to be preserved. If we can get the decisions back to the state level and decide the policy, then we've got to decide what's the right welfare policy in North Carolina? What's the right education policy in North Carolina? We get the federal government out of it, you still got to fight for freedom here. You got to get your government to do the right thing here. But you have a lot better chance of being successful at the state level on those issues than you do at the federal level. So we're never, ever, ever going to be at a point where we can just sit and rest under the apple tree. God calls us to put on the armor of God, and the armor of God has only armor on your front side, not on your back side. And when it says, the gates of hell shall not prevail against you, just to use the analogy here, the arguments I'm hearing tonight are the gates of hell going to prevail against us. No. Ladies and gentlemen, George Soros, and all those people, the gates of hell are a fence. They're not an attack weapon. They're holding off area they have unlawfully grabbed and said, this is our turn. I'll go after this. 2 questions. Okay. All right. I'll go to sequence. Shut up. Okay. The way you prove the gates is we go back and take back our land. That's what that analogy means. Is we go back and take back our land. They said it's their territory. That's the analogy that I prefer to use out of the Bible. Let's go take back our land. Let's take back our freedom. And freedom is for everybody, not just for Christians, not just for conservatives. It's for everybody. If California wants to have a socialist state, let them. Amen. See how it works out for them. Massachusetts wants to have a socialist state, let them. It's a free country. I want this to be a free country where every state gets to decide its policy for itself on these issues. And the federal government does what it's supposed to do, that is protect our borders and provide the national defense. We get to that, we got a lot of improvement. Ms.
Amen.
Baker,
President Adams, she's a long-term member, she's about to split a gut.
Okay, that's right. She's the one.
She's the one.
Now, let's assume a couple things.
Okay.
We're at the year 2018.
All right.
And you've been successful. All right? Got that, got everything. How are we going to implement it?
Okay. Well, the question is how we're going to implement it once we've been successful. There's going to be some things that can be implemented lickety-split. The U.S. Department of Education will cease to exist lickety-split. I used to work across the street from the U.S. Department of Labor. They've got a mural inside. There's a painting. There's so many OSHA violations in this mural called Building of America. Apparently, if America was ever going to get built, we didn't need to have OSHA. So I think the Department of Labor, my lifelong dream, could be lickety-split, turn it into condos. And so there would be a few things like that that would have to be done, could be done rapidly. If the states are going to pick the Supreme Court, you pick an end date for the current justices, and you pick new judges under the new rules. That's lickety-split. There are some things, mainly the entitlement programs, where people have depended upon them, that you have to do it over time. And I think what would have to happen, this would have to be approved at the convention, this would be a part of the package that comes out of the convention, is that there'd have to be some mechanism for that to be done over time. And I don't think you can trust Congress to do it. So what I would do is effectively the equivalent of calling the federal government insolvent and appointing a committee of trustees to deal with that. And I would appoint one from every state. Have the states figure out how to appoint their one person. And have effectively bankruptcy trustees. The federal government owns a whole bunch of stuff, like 90% of some western states. A good friend of mine in the oil industry says that just the oil rights on federal land is worth more than the stated $17 trillion that the government admits to as the national debt. And so if this group of trustees had control of all these assets, they could work them out in a proper way over time, there would be a way to fund all the liabilities that the federal government has dug for ourselves. As the newly restrained Congress would have to operate under the new rules that doesn't allow them to spend more than they need. That's the basic idea for how it would work. Yes, sir, you get the last.
First, thank you for being here for us. You mentioned previously about two separate constitutions, the Supreme Court Constitution and the actual Constitution. Is there a way to research the veracity of the statement? And also,
The veracity of what statement? The one that I made?
you're saying you said earlier, there are two separate constitutions.
Right, okay.
One that the Supreme Court was on,
Right.
and one that's actual. Also, is that a dirty, large lie? There's two separate constitutions.
Well, okay.
Also,
Well, all right. Go ahead.
now, if that is just a lie, how is any Supreme Court ruling judicially justified and upheld if that is the case?
Can you say those words again? I just didn't hear you.
How is any Supreme Court ruling judicially justified and upheld if that is the case?
Okay, all right. The original meaning of the Constitution on the 14th Amendment is this. No person shall be denied life without due process of law. Person in 1868, when that was adopted, included unborn children for all legal and scientific purposes in this country. The state laws were overwhelmingly in place that said that unborn children were persons for the purpose of the right to life. That was the opinion of the American Medical Association, and that was the state of the state law when that provision was ratified. The original meaning of the 14th Amendment is the right to life amendment. The Supreme Court jettisoned that in Roe v. Wade and wrote themselves a statute. We all obey Roe v. Wade, despite the fact that it differs from the original meaning of the Constitution. That's just one of great number of examples I can give you where the Constitution as written is quite different from the Constitution as interpreted by the Supreme Court. We all know the grisly reality. The reality is the Supreme Court's edict results in the murder of thousands of babies every day in this country, every single day.
Would that go liberty split?
It could, under a convention called for that purpose, yes, it could. And so the reality is we have the Supreme Court ruling because we are people who obey the law. And we either need to go into open rebellion against the law, or we need to change the law. We need to change the Supreme Court. Those are our options. And has the Supreme Court correctly followed the Constitution? No, they haven't. Is it, but what are our options?
Sir,
Yeah.
my primary question was, is there a way for me to go online and research? Because I'm currently studying the Constitution. Is there a way to go on and research that state?
Oh, you can, I have a 25 lesson DVD series on the Constitution that you could go study. It's called Constitutional Literacy. It'd be a good thing for you to do. But you can't go online and do it. You can buy it. Or you could, Hillsdale has one that's not quite as in-depth. You can go online, Constitution 101 by Hillsdale College, and watch that. And so it's free.
I'm not disagreeing with you.
Yeah, just if you want to study it, go find somebody who's written about it or has taught about it, who knows what they're talking about, and study what they say. Thank you so much. Thank you for being here.
Dr. Farris, you guys have been a great audience. We've been going at this for a couple hours now. You've been very patient.
Lieutenant Governor Farris.
We're going to take questions, but we'll hang out afterwards.
Well,
We'll hang out.
I've driven 1,200 miles between the Hendersonville town hall and this one, and they were billed as town halls with our lieutenant governor. When will you hold one in eastern North Carolina where we can ask you questions?
I'm getting there, so thank you. So we've done 2 of these. We did one in Hendersonville, and we're doing this one. There aren't any more scheduled for this year, but we hope to do more in the coming year. And this is part of the education process. And as you can tell, people have a lot of questions. There's a lot of questions out there. There's a lot of people that are fearful of this process, and we need to continue to help educate people and bring them along. So I encourage all of you to go to the website, conventionofstates.com, and learn more. Continue to learn more, as I have to do as well. But we thank you for your patience. We thank you for coming. Just quick, because we got to wrap up.
Make sure the lieutenant governor gets this one.
Can you tell us, can you please on your website tell everyone when you have time what the process is, why you are using executive duties to push something to legislators? I don't understand the appointment process, and I don't understand how this is funded. For your benefit, I'd like to see you make that a little more transparent for all of us, because I've been a little confused about the blurring or the joint jurisdictional implications of the executive branch of the North Carolina state government working in tandem with the legislators.
There's no money going to this. This is all private money. Everything's privately funded through convention states. I'm not getting paid to do this in any way.
Promoting their ideas.
Right now, I'm promoting the educational process of people in North Carolina, Lieutenant Governor. That's my right now. Right now, I am supporting this process. I'm supporting moving forward with this process. It's a great educational process for North Carolina. It's a great educational process for America. It's something I think we need to continue to move forward with. Absolutely. As Dr. Farris said, we're running out of time here. To answer your other question, as far as the appointment of Bert Jones and Chris Millis as president of the Senate, they come to the state and say the president of the Senate has the authority to appoint the members to go to Indianapolis.
They're in the state. They're representatives, but they're not even members.
The Lieutenant Governor is the President of the Senate.
I am the President of the Senate, as Lieutenant Governor. I'm legislator.
They're not senators, they're.
That's right. That's right. So we're to appoint we're to appoint a legislative delegation to go, and that's what we did. So they were the ones that wanted to go do that, and we talked to them, they wanted to go do it, and they're the ones that went. And that will change over time as well, and other people get engaged with that. But thank you very much for coming, and Van's going to wrap this up.